Just an aside, Malas, all that was done in the last 10 minutes was reference to everything but the whip. The only issue relevant is whip. Your Lordship would be asked to turn parliamentary and party-based democracy on its head if you were told that whip is not issued by the political party. What your Lordship has shown just now is totally irrelevant and red herring, because it is intimating to the Speaker and the House that in this House, my leader is so-and-so. That is a communication between those in the House communicating with the Speaker. Speaker has to know whom to communicate with. It is no communication of the party with its members. That's the whip. And that the party issues, the party decides. But that was apart. We'll come to those rules. So this is completely irrelevant. It cannot be anybody's case that in the context of a whip, the party, the political party is to be ignored and the legislative party is to be looked at. Now, but leave that aside. Let me go in my own sequence first. I'll come to that. Well, your Lordships ended before lunch with a simple finish with a flourish, about democracy. Let me just start with that. Well, according to my respectful, I'll come 7, 8.
You follow the same note, Dr. Singh?
Now, on the note, I have an apology, little bit of a mix-up. The note, my note came to me in the morning. I corrected it and sent it back. Somehow it didn't go through. So they have filed by mistake the old note, which I had not corrected. Luckily, sitting here, I found it, and I corrected it. It has been, we've got hard sets, it's been emailed, but your Lordship's uploading is in your Lordship's domain. So, the court master was told all this, so your Lordship may have to either upload it or have the hard sets. Because there's a mix-up, the uncorrected note came here. I made many corrections in that. So, this is A7, Lordship call it A7. And my learned friends have all got it, pre-lunch.
Old one remove kar dena.
This will be in substitution, I'm sorry.
Remove kar dena.
This will be in substitution of A6. A6 is the wrong one, the earlier one.
A6. A7 is this. Region the final PDF. Remove kar dena. Naya upload kar.
Let me just summarize orally and then I'll come to the note, because it will be much easier to follow the crux of my submissions. May I start? Your Lordships have got either the hard copy or the soft one, whichever your Lordship is using.
Same. Yeah. Same. What is the change?
No, there are a lot of changes. Your Lordship may just take this one.
Starting is the same paragraph.
No, starting, but there are changes. Lordship may junk the other one, otherwise Lordship will be confused with the other one.
So just comparing, but
no, there are changes. Lordship may just tell them, your Lordship's assistants to delete that earlier A6. That's all. Otherwise, there may be some confusion. There are whole sections which are added, etc. That's all right. Your Lordship will use this. Now, the first submission, and I'm not going to follow this sequence. Allow me to oralize. My first of my 8 facets is something which is repeatedly fallen from your Lordships, and yesterday it fell directly from my Lord Justice Narasimha. That your Lordship is concerned about democracy, majority becoming less, or your Lordship use the word overwhelming numbers going this way or that way. This connects with that. Mr. Subhash answered in one way. I'm now giving your Lordship a different facet. Because my submission is that your Lordship has to go back to the origins of the 10th schedule. And first point under this head is that the 10th schedule has 2 components, not only one. One is a prohibitory negative code. It's a negative code. So a negative code is what you should not do. Violate, whip, voluntary resignation, cohabiting with other people, etc. But there is also an affirmative, positive part of that code. And what the 10th schedule does is to strike a balance between the negative and the positive by a constitutional amendment. It is my respectful submission, it is vital for your lordships to give effect to both negative and positive in letter and spirit, because your lordship is actually implementing the constitution. And some of the arguments of the other side have bordered on suggesting that a mere, I'm using the word mere advisedly in comparison to a constitutional text, a mere symbols order will be competing with a constitutional text. That would be completely anathema to all known principles. What are these two codes, Balas? The negative code is that you, in a nutshell, I'm just saying, in a nutshell, I'm oversimplifying, you will not voluntarily give up membership to 1A and you will not violate whips to 1B. Just in a broad Balas summary. What is the affirmative permissible activity? You are entitled to dissent only within that permissible zone. Otherwise, why enact the 10th schedule, Malas? Prior to 85, you didn't have the 10th schedule. You had Jungle Raj, which you called Ayaram Gayaram sometimes, but then you can also justify that in the name of free speech, free action. What you did here was you allowed a zone of activity, permissible, affirmative, but you cannot say that I will go beyond that permissible and thereby violate indirectly the negative code also. What is that permissible activity? The affirmative code of conduct. One is a faction or a split till the 91st Amendment. They gave you an escape route, advisedly, consciously. That has gone. It was there. So, the constitutional framers thought that along with a negative code of conduct, so as not to stifle you completely, we give you an escape route, exit route of faction or 1/3 or whatever it was called. Second, merger. Third, and this is actually the most important part of 10th schedule. Elections, barring a few cases, in the days of 1960s, etc., there used to be a very strong, large number of independents. Independents have now dwindled. The statistics show, even then, in terms of 545 Lok Sabha, you had hardly 30, 40. But independents commanded a coordination. My father also got into Lok Sabha on an independent party-less ticket. So I know that time it was Mr. Nath Pai, so many people. But today, even then, party democracy was, everything was based on party. You got a ticket and you fought and you won because the party projected you as its candidate. That is now, much, much truer after the 60s, 70s onwards. Today, the number of independents compared to the 60s would be a fraction. So it's party-based democracy. You like it or not, it's not for anybody to question. We've chosen it, but there's nothing perfect. Some people say US is better, some people say European, but this is what we've chosen. Now, this third balance.
Third point is what? What is the point?
One is
split is permissible,
split.
merger
Second
is
merger.
permissible.
Third now.
What's the third point?
Third comes with the light of what I said just now. The whole idea of the 10th schedule is resign and recontest. That's what is stopping you from doing. You enter the door through this door and then you retain your ministership and seat while exiting through the other door. Sorry, not permissible. Resign, have the courage of your... Now, you are a very vocal freedom speaker. You have the courage of your convictions.
Which Justice Jeevan Reddy referred to in that extract.
I'll be dealing with some of
It
that.
was not in the context of the 10th schedule.
But I'll be dealing with that. Some judgments have referred to it. I'm going to suggest, because this is the core question my Lord Narasimha asked, my Lords asked earlier. What do we do when an overwhelming set of people want to express dissent? 9/10, let's say 9 out of 10. Let's take an extreme example. How do we balance and countervail these two competing balances? The 10th schedule says you can go thus far in balancing, not further. Whereas if you are so much for free speech, courage of your convictions, this is a rotten party, I can't say, resign and contest. Recontest, what is the problem? Then the fourth is the exemptions. There's apart from merger, there's an exemption clause, condonation, whatever. All that is given there. Now, what we have to see is that if a constitutional amendment balances the prohibitory with the affirmative part, you cannot find an excuse to circumvent the prohibitory part by going beyond the 4 avenues of the affirmative part. Now only 3. Faction is gone. Now, let us take this further, because that's your Lordship's query. I'm sorry, there is a 5th one. I forgot. There's a 5th one. I'm now breaking it up. There is a 5th balancing on the affirmative side. You are so concerned about free speech. You are resigning is one. Or you absolutely hate where you are. You go to the Election Commission and start your para 15 proceeding that I am the real party. But you do that without indulging into the prohibitory part. That's keeping the sanctity of the 10th schedule. Now I'm addressing the core dilemma of my lords. Let me develop it, in a minute. That's also a statutory remedy, lower than constitutional. So the 5th is, now actually only 4, because that faction is gone, split is gone. So 4. The 4th would be file a complaint to the Election Commission, say, look, 9 of us are standing here, we are the party, recognize us. Till then, don't do any prohibitory activity. The Election Commission will or will not recognize you and is subject to challenge. What does this do, This maintains the sanctity of the 10th schedule and maintains the negative and the affirmative parts of the 10th schedule. What does my lord normally prefer? A option I give your lordships which reduces the other option to vanishing point? Or an option which harmonizes both? Elementary principles tell your lordship by 1,000 cases that your lordship prefers the harmonization approach. Elementary common sense shows that my learned friend stand reduces the 10th schedule to vanishing point. It is as good as a dead letter or a repeal. Which is better? The answer is self-evident. Now, here, just see, how this dead letter vanishing point arises. You don't resign with the courage of your convictions to fight another election. You don't go to the Election Commission till much later. Almost a month, just under a month. After 21st, you went to Guwahati. 19th, you go to the Election Commission. 2 days before a month is ending. You don't seek condonation. What you do is, what I call a 3 steps novel procedure to annihilate the 10th schedule. It's a 3-step novel procedure. Step 1 of which is disable the speaker by giving him a mere notice. So the man can't touch you on the 10th schedule. Just see, my submission of harmonization versus vanishing point. Step 2 of this sinister 3-step novel procedure is to forward resolutions parallelly to the governor, who in turn makes it the basis of a trust vote direction. And the final step 3 is the act of being sworn in as Chief Minister.
Sorry?
The act of being sworn in as Chief Minister. With another party fully supporting, in whose lap you were in Guwahati. Now, I'm not on the... Just kindly consider. You don't follow the affirmative part, which gives you play in the joints and leeway, flexibility. You don't resign. You don't merge. The most important, interesting point is you don't merge. Just see for a minute that B, 4B. If you are sitting in their lap and they are supporting you, and the last minute, instead of them becoming Chief Minister, they make you Chief Minister, what is the problem with merging? So, you say, to hell with the 10th schedule, it gives me an escape route, I'll ignore it. I'll go to the 3 steps. And the language, without opening it, where his original political party merges with another political party, and he claims and any other members of the original political party have become members of such political party, or as the case may be, of a new political party formed by such merger. Well, this is directly snooking a nose at the 10th schedule, which is a constitutional creation. It is, well, I'm sorry to use colloquial language, it's actually saying, look, to hell with the 10th schedule, we have made this 3-step procedure. Why on earth could you not recontest, resign, merge, or the fourth one? Condonation, I'm not getting into, that's another one. Go to the Election Commission and file a complaint then. On 21st, instead of Surat and Guwahati, why did you not file the Election Commission? So this is the first answer. This is one of the best answer at least I can give to the direct question, but there is a consequential answer further ahead. I'm putting it against myself and trying to answer, because I put this question to myself and Lordship asked it yesterday. Now, a possible argument will be twofold. That is no argument, because how it works in actual law, a fact is not an argument against me. If the law is a prohibitive and a affirmative, then you jolly well follow it. That's the object of creating a constitution. But now I'm giving an answer against me, even though it doesn't arise in law. The answer is, what happens, Mr. Singhvi, if between me, that is they, applying to the EC and doing these things which Mr. Singhvi is advising them to do, the speaker disqualifies you. I'm putting it bluntly against myself. First answer is, so what? Why was the 10th schedule created? Is the speaker doing something unknown to law? But there's a better answer. If he disqualifies you, there is full judicial, this is on the basis wrongly. There is full judicial review. No, but you can't, your lordships can't find a solution to everything which the Constituent Assembly, the Constituent amending people did not make. What is this answer? That what do? I will be disqualified. Well, jolly well you'll be disqualified because the 1985 framers gave this power to the speaker. Is the possibility of an abuse ever the test of the power or its existence? Can it be? Otherwise, how will your lordship decide anything? Yes, that phrase comes from Rajanarayan versus Indira Gandhi. Possibility of abuse is not the test of power. Give that citation.
Hindustan judgment. Hindustan construction, some judgment is there.
Also Hindustan construction.
Abuse of power cannot be there.
Your lordship should judge everything. Oh, what will happen? What may happen? But that's not the question. Here, and your lordship is talking of lesser cases. Here, the constitution was amended to give this power. And the apprehension is, I will not go on 21st to speaker, to EC. I will go to Guwahati because I'm scared of a disqualification. Now, let us look at the second. I'm giving a lot of extreme examples against myself. You have a full review possible. My review is much more truncated. It takes 1 year for me to get this hearing before your lordships. Your review is immediate on a wrongful decision against the speaker. And your lordship knows, Kyoto says, after final decision of the speaker, you will get a stay of that. You can't get a stay while he's deciding. You can get it afterwards. Of the disqualification also. Only a quia tibet is stopped.
You're comparing that with what?
With the fact that if you don't do this and stay and make the 10th schedule a dead letter and install a new government on the basis of ignoring the 10th schedule, that is much less reversible by sheer passage of a few days than your right to challenge. Today, what is the whole argument? It's a scrambled dead, it's a fake accompli. Your lordships can't reverse it. It's 1 year down the line. That's the real argument today. That's the argument we are facing. Now let me give your lordship another bizarre example against myself. These are not normal examples. Whereas I don't know of, except a very few number of cases, where you have the courage of conviction to resign and recontest. That resignation is impeded. It happens. There are 2 or 3 judgments we have. But normally, let me assume against myself that I resign because of my high standards and my resignation is not accepted by the speaker. That's the worst I can assume against myself,
Right.
I can't assume something more than that, Again, the speaker can only reject my resignation and disqualify me. He cannot do anything more. The speaker cannot say, that you shall do this or that. He'll at the most say, I reject your resignation and I disqualify you. Same remedy. That remedy, your lordship will stay in 2 seconds. Suppose your lordship had an MLA who resigned to fight a new election, and the speaker, there may be bizarre cases, I don't know, speaker said, no, I disqualify you. How long will it take a court to give a stay of that order? I mean, your lordship is dealing with these cases on and off every day, in some form or the other. But here, none of these 4 or 5 possibilities is allowed to be tried, because you adopt a 3-step procedure to annihilate the 10th schedule. Which brings us to the harmonization principle. I'm not going to cite law about harmonization. From ordinary petty contracts to constitutional law, your lordship's first principle is harmonization. From statutory, delegated legislation up to the constitution. Whereas I want to make the different point here that why did the 10th schedule come? We'll read Mr. Ashok Sen's speech in when he piloted this 85 thing. The whole purpose is that you have come through a party seat, you go and face the electorate again, whether with that party, independent, or a third party. That's the whole long and short of this. Have your lordship ever heard this happening except in some very rare cases in England or other democracies? There's no concept, I've come on a party, I'll either resign or I'll just leave that and fight again from another party. That was the whole purpose of this. But what you are telling the court is that no, I will affirmatively not resign. I will not go to the EC. Why? Because I'm scared that somebody will disqualify me. But then what was Mr. Ashok Sen enacting in 1985? He's enacting a power of disqualification for changing a party. What is the purpose of 2/3 of parliament saying so if you can simply...
What is the harmonization principle that you're referring to?
Harmonization is this 4-fold, 5 originally with the faction, otherwise 4, are the flexibility, play in the joints, affirmative, permissibility part of the 10th schedule. And the 2(1)A, 2(1)B is the negative prohibitory part. You can do all these 4 without doing the negative part. For the negative, you don't have to violate the negative part for any of these 4. I will say, even if you go to the election commission, you don't have to violate a whip. You don't have to voluntarily give up your party. You say, I'm on principle, please decide this.
So in other words, you are saying other than those 5 instances,
4 now.
Everything else falls within the net of 10 schedule.
And one more thing I'm saying. That 10th schedule, absolutely correct. And the 10th schedule has both parts. It has those 4, it has a negative. It creates a whole code by itself. Harmonization means that your lordship will adopt my submission and interpretation because it harmonizes the negative and the positive. Now for 30 seconds, see if your lordship does not adopt the harmonization principle. The only thing your lordship will have to validate is the 3-step procedure. There's nothing else, it's staring your lordship in the face. The 3-step procedure, I want to ask myself, in which case will the 10th schedule bite? Let's be very blunt. What your lordship will do is your lordship's domain. But today, your lordship's other option, other than my option, which I am submitting most humbly and respectfully, is adopt the 3-step procedure or validate it or recognize it. But then how will 10th schedule apply? It cannot. And then, your lordships would be actually adopting an interpretation which reduces the 10th schedule to vanishing point. Actually vanishes, that's vanishing point, it vanishes. Every case of defection, I will say, I'll not resign. I won't go to the EC. I won't merge. Merger is given to you by the para 4 of the 10th schedule. I will not do it. But, as your lordships was told, I am the party, I am the overwhelming majority, I am the main person, I am it. I am it. Therefore, to hell with the 10th schedule. So, on principles of interpretation and much more so of constitutional interpretation than even statutory, this is a much better way to look at it than the contrary view. Because your lordship gives meaning to both sides and your lordship does not adopt something. What is this other adoption which is propounded to your lordships? On the high moral principle of democracy, dissent, free speech. Each of my 4 options gives you that option. So what the 10th schedule does is, it says, I am giving you a free speech option. I am giving you a democracy option, but within my own terms. I'm not giving you a jungle Raj free speech and democracy option. Otherwise, why would I enact a 10th schedule?
See, but merger, Dr. Singhvi, was not an option open to them because they were not claiming to merge their party with either the BJP or any other party.
With respect, I'm sorry to interrupt, Velas. Why not?
So, merger was not an option.
No, it was an option. Velas. They did not
Of
choose
course,
to exercise
you're
it.
right, you're right.
That's correct.
It's an
They
option.
chose not to
available
exercise an option.
in the abstract, but they were not following the merger route at all because it's not their case that, look, this part of the Sena
That's exactly
has
my point.
merged with another party. That is not
That's
clear.
exactly my point with greatest
Then
humility.
the only point is that in a situation like this, where they say that we have lost faith with the leader of the party,
Yes.
then the only option according to them, according to you, is that you resign and recontest.
No, Velas, no. I will stick to my 4 options.
That's
I'll say all the 4 options are available.
No. What do they do then?
No. Whereas resign is one.
Right.
These 9 people will merge with another political party. Why not? But the fact that I don't exercise an option doesn't.
That is not an option because merger means that their political identity as the Shiv Sena is lost then.
Well, then in that case, if the 10th schedule says that I recognize only this path of exit from this room, you can't say I'll make a new tunnel to get out.
But you know, Dr. Singh,
He can't
this
make a
part
new-
of your argument is a problematic argument. That look, I'll tell you why. Because your argument postulates that if you have a dissension, then the only way you can express the dissension is to leave the party and merge somewhere else.
One,
They say, sorry, we don't want to leave. I mean,
Right.
ideologically, I am a Shiv Sena man. I don't want to leave, he says. He says, I don't want to leave the party.
So as per your
Kindly see, Bharat,
argument,
now kindly see the consequences of it.
even if somebody applies to the election commission at the initial stage instead of in the legislative assembly
Correct.
and says that we now want the political party to
That we are the
accept us
political party,
as-
recognize us.
So even that, according to your argument, is impermissible then.
No, because
So because that's outside the
so long as
5 instances that you have given,
no. One of my 5 is EC.
he's not resigned.
I beg your pardon. No. One is resignation, one is split, which is gone now, one is merger. The 4th is EC.
He's saying that.
4th is EC. Now, whereas if I apply to EC without violating a whip and get a decision, if I apply to EC without voluntarily resigning, it's perfectly permissible. I can't be saying I'll topple first and then I'll apply to EC.
So remain a member, be a part of it, and
Whereas
contemporaneously
vindicate your principle. Absolutely. Whereas I just see the reverse of it, but just consider how it will apply. You first topple the government, then you go to the EC. And why did you like the 10th schedule?
That we understand.
No, and Malas, also, apropos my Lord Chief Justice query, Malas, are you harmonizing or not? Malas, one more thing. The fact that you don't choose consciously not to exercise an option does not mean you can wish away the option. The option is a constitutional option. It's a constitutional option. It's as equal to split as it was earlier. You don't exercise it, it really amounts to saying this, I want to avoid the 10th schedule. So I will put blinkers and close my eyes to 4 options available. 4 constitutional options, the 5th one is deleted. And I will choose a new option, which is only the 3-step procedure. First, disable the speaker. Second, approach the governor. Third, be sworn in.
See, the negative prohibition in the 10th schedule is twofold. One, voluntarily giving up a membership, and 2, defying a whip, 21A, 21B. The 10th schedule certainly does not have any provision by virtue of which there is a prescription if you do not give voluntarily, if you do not give up the membership of the party, and yet exercise the right of working your remedies within the party.
Then you cannot be held to be a defector.
Right.
And that is the whole purpose. You were elected.
That's exactly the case, no?
No, but then in that case, why did you enact the 10th schedule? 10th schedule is not saying that Article 19(1)(a), just see 194, very interesting article. It is not saying Let me put this harmonization, which is a very important principle, in another way. What is the scheme of this entire system? Well, if your lordship were to make a standard as broad as if you have a dissent, you can violate the 10th schedule, then your lordship is unmanageable.
But your
Unmanageable.
argument, Dr. Singhvi, would be
Yes.
the extreme argument on this side, which possibly you can adopt also, is that any dissension amounts to the voluntary giving up of the membership of a
No,
party.
I'm going to give more. I'm not extreme. The other argument is extreme. I'm going to give a harmonized answer. Immediately to that, the principle can never be dissent. I'm not happy, therefore I can go. Three answers. One, everybody has dissent. Which political party? There are enough inbuilt outlets within the party to express dissent. One. That is what your lordship will always say. Two, the dissent within the party at the appropriate fora can be followed by any of these four. Three, you, if you are having dissensions and you are not satisfied with the party system, then you will simply express it that I am resigning or doing going away with 9/10 of the people. But how will you say that mere disagreement entitles me to topple? Here they have not expressed dissent. It's not a case of dissent. I have not gone out and spoken against the party. Dissent plus, this is dissent plus. Dissent plus toppling. Your lordship remembers I started, I think there was a Nabam Rebia hearing. Your lordship notices 191.2 and 194. Your lordship may not remember that, but just kindly turn to that for a minute. 191(2) is a clear statutory, constitutional prohibition in the 10th schedule saying you shall be disqualified. That's the 10th schedule comes from 191(2). Now, 194, which follows 2 clauses later, says, subject to the provisions of this constitution, there shall be freedom of speech in the legislature. And 19(1)(a) is even more reasonable restrictions. Now, it can't be that mere saying free speech, I can violate, I'll violate, you can act within the party constitution. Whatever the party constitution allows, some party constitutions have even appellate bodies, some have 2-level things. You can actually do all of it. Before you go by these 4 escape routes of merger, resignation, you can do all of it. But ultimately, if it doesn't work, you have to take these 4 routes. And 194(1) makes it clear, subject to the provision of this constitution and to the rules and standing orders regulating the procedure, there shall be freedom of speech in the legislature of every state. This is not an open-ended charter. And plus, kindly see the consequence.
Dr. Singhvi, according to you, when does the governor then order a trust vote?
No, the governor has no role at all. In such a situation, governor, first answer your lordship is when the government is formed. Or when the government is about to be formed. That's the inception argument. The governor will never come into a 10th schedule situation. It's what is your lordship considering? An intra-party dispute. At the end of the day, what is this dissension? I don't like you. I don't like you. Intra-party. How does it come to intra-party dispute? How does it even recognize it? There are all kinds of feuds going inside parties. How does my lord lay down in English language a judicially manageable standard to control the governor peeking into intra-party disputes? It will be the thin end of the wedge. This is nothing but political party A intra. The governor will deal with some constitutional issue or something relating beyond intra-party. And how will the governor deal without any specific article, mind you, in a sense, superseding and overdoing the 10th schedule, which is a constitutional article, with 191(2), which we tend to forget. 191(2) read with the 10th schedule.
Only when the government
The couple of things. Step one was, as we saw, the three steps that you told us. Just
Yes,
one second, I'll just go back to it.
Correct, Manoj.
Notice of removal to the speaker,
Yes.
resolutions given to the governor, and the act of being sworn in as CM.
Correct.
There's one step earlier, probably one step which you can also add there, which was the governor's trust vote communication.
I'm grateful, Manoj. I'm grateful.
Right. Now,
Fourth step.
there,
procedure.
notice of removal of the speaker, we are not really called upon to adjudicate upon the validity of the. क्या हो गया? तो क्या है भाई? You said 3 o'clock, so they can. Oh, नहीं, अभी time है. जाओ.
No.
फिर क्या ना?
Except in Nabam Rebia. Your Lordship, if your Lordship chooses to refer, would have that issue. Nabam Rebia,
If we choose.
in the broad, no, I'm saying it arises. I'm not saying your Lordship may have to for this case. I'm saying that's the core issue in.
Of course,
No, I'm saying, Manoj, it's an issue. which
the governor asked for a trust vote.
Yes.
Two ways of looking at it. While the governor had material to call for a trust vote, in which case a further issue would arise as to whether he was justified in calling upon Shinde to form the government.
Pinpointing, picking out a person and saying.
Picking out a person, because
Correct.
even assuming that the governor had material to call for a trust vote, what is the basis for picking up Shinde? Second, that the governor had no material to ask for a trust vote. That there was no valid material at all
That's a
on the
core
basis of
question.
those three circumstances.
That's a core question. And Manoj, that goes to the heart of the matter. If I may digress for 30 seconds, Mr. Tushar Mehta was right when he quoted the couplet, but perhaps didn't realize that the second sentence applies against him. He quoted Bashir Bhadra to say, "Chup rahe to galat fehmiyan और भी बढ़ी, उसने वो भी सुना जो मैंने कहा नहीं." उसने वो भी सुना जो मैंने कहा नहीं. Well, the governor in his letter at 326 PDF talks of a resolution to exit the government, which doesn't exist at page 55 of the resolution itself there. So he's hearing things जो कहा
The
नहीं.
resolution doesn't say that we are exiting the government.
Yes. So he heard something.
We had wanted to.
Well, I found a more appropriate one for Mr. Mehta. I found a more appropriate phrase for Mr. Mehta, not Bashir Bhadra.
So really, question was whether there was a valid exercise of power by the governor to call for a trust vote. And but what happens if we come to the conclusion that there was no valid exercise of power by the governor to call a trust?
Everything false.
Everything false is very.
No, Bombay. I'll be dealing with Bombay. That's the core question. Your Lordships is saved a lot of unnecessary exercise if your Lordship comes to that conclusion plus follows Bombay, which in any case is.
So then you, according to you, what? We reinstate the Uddhav
Just
Thackeray
straight away. Let me first change my tack and go to Bombay.
But you resign, no?
No. That's I covered in my note directly. 5 reasons. Justice Shah asked me that in the beginning. Your Lordship asked me that. I'll straight away answer. That is actually red herring. My resignation and not facing the trust vote is irrelevant. Completely.
But that's Ms. Dr.
No, I'll deal with it. So let me deal with it. So let me deal with that.
It's like the court being told that you reinstate a government which has.
No, it's
an acknowledgement by you.
I hear your Lordship loud and clear.
Resign.
It's a question asked earlier, and it is actually a plausible looking thing, but it's actually irrelevant. I'll show that in a minute.
No, Mr. Kapsil, how can, just hypothetically,
yes,
how can the court reinstate a chief minister who did not even face the floor of test?
Your Lordship is not reinstating anybody.
And what will be the consequences?
Your Lordship is and should and does, and Bommai says it more graphically, restore status quo ante. That's the meaning of a.
But Ms. Dr. Singhvi, it would have been a logical thing to do. That's where we are, it would be a logical thing to do, provided you had lost the trust vote on the floor of the assembly.
Lordship may just flag that. I mean,
because then Clearly, you have been ousted from power because of a trust vote which is set aside.
Correct. Duty bound to satisfy Lordship, and I believe that.
Right. Now, our problem is look at the intellectual conundrum.
Yes.
That it's not that you have been ousted from power as a result of a trust vote which was wrongly summoned by the governor. You chose not to. For whatever reason, you didn't want to face the trust vote.
I
and
face
that's
that
what
squarely.
is-
Allow me, Malus, I'll change my sequence and come to that first right now. May I, Malus? Because straight away your Lordship's conscience should be satisfied. This is a red herring. It should not deter, will not deter in law, your Lordships. If your Lordships comes to the conclusion of the other one. Give me just 5 minutes on this. May I end the first part, Malus? That is, Malus, this affirmative and negative code.
Yes, that you
With only one, with only.
Now, Dr. Singhvi, we are 17 minutes past or 18 minutes, closing on 18 minutes past 3 p.m.
Tuesday, Malus.
I think 3:30 we'll close now. I think we have seen everything now.
No, Malus, your Lordship, I'm asking, 3:30, it's now, Malus, 3:20. I've done 1 out of my 7 points. Malus, this is a matter of some moment.
But Dr.
I'm not
now
going
you have
to
conclude. I mean,
Malus,
you can't just go
in. Conclude, Malus, but it is a very useful, when your Lordship asks questions,
now your points are really alaps of your...
No, Malus, with respect.
You are in rejoinder council.
Malus, I have argued 1 out of 8 points. I would not otherwise take time. And Malus, your Lordships, it is not intended
Dr. Singhvi,
to stop your Lordships, Malus, querying, because your queries actually make us think.
All right, Dr. Singhvi, you are always very precise. You are always very precise. Now go into the next point.
Your Lordship's compliment is intended to render me speechless, Malus. I'm not going to be speechless.
No. No, it's not
Allow
like
me,
that.
Malus, a
Dr.
few
Singhvi,
minutes.
there is too much. The point is,
This is,
there is a lot of stuff that we have to reflect on now, and we just want you
so,
to now
maybe your Lordship will just
in
a
rapid
little over
fire
4 o'clock.
summarize it for us so that we can have...
Let me speed along, and Malus, your Lordship may give me a few minutes after 4. See, I am very keen to finish, Malus. I'm not, till now, Malus, I have not repeated a single point. I've given your Lordship a new facet.
Now not interrupt you. Go ahead.
Yes. So, Malus, let me end this first point by saying, let me end the first point by asking myself a reverse question. What happens in my first point of affirmative and negative if your Lordships were to accept their interpretation? That's a good way of answering my Malus proposition. Namely, your Lordship will have nothing left in the 10th schedule. How does the Lordship operate both? The 4-step or the 3-step becomes the norm and will be followed in every case to defeat the 10th schedule. That's my first point. Second point on resignation. Now, Malus, your Lordship also has to deduct Malus till 2:20 my learned friends were occupying your Lordships. And now, Malus, now the second point. Just look at this resignation trust vote a little carefully, Malus. I have 3 or 4 answers. It is irrelevant for the following reasons. Well, it's just turn to para 14.
The reason why we are wrapping you up, so to speak, is not because you have no case.
No, Malus.
I asked you to wrap up only because now the burden shifts
now
heavy on us to, as adjudicators, to apply our mind and step back and
so let me, Malus, now
decide.
Speed up. I think, Malus, oral things help, but to speed up, let me ask you to read para 14 of my note, A7. Para 14.
Just formulate it for us.
Yes, the formulation.
We've now got a...
When, Malus, now I'm answering the second
14,
head. I had 6, 7 heads. This is my second head. And it starts, Malus, this head starts at page 6. It starts at para 9, page 6. Resignation.
The act of resignation.
The act of resignation subsequently on 29 June would not defeat and would have no relevance to the reversal of the illegal action of the governor of 28/6. And in accordance with precedent, this honorable court should effectuate a real and meaningful remedy. Now, as your Lordship recollects my A3 submissions, para A to N, which are repeated here, I argued, ibi jus, ibi remedium, fait accompli, status quo ante, all that. I'm finishing off in 1 para. I'm not arguing. I'm just reminding your Lordships. Now, skip all that and come to Malus para 14 for a minute. Does my Lord have para 14? Once the illegal act of the governor is allowed to be implemented, the result was a known and foregone conclusion. Factually, there was no need for the ex-CM to subject himself to it. The most important thing is it's a prior challenge. The illegal act of the governor is a prior pending sub judice challenge before the trust vote.
So you are really saying that Mr. Uddhav Thackeray resigned only because he was called upon by the governor to face a trust vote?
I'm grateful. After I had filed a petition, after I had made it sub judice, and after I had said this is completely unknown to law, don't allow it to go on.
And you are frankly accepting the fact that, well, you resigned because the trust vote was going to go against.
When you do an illegal act, the consequence of that is known to me. Now, just to save time, let me read it. The crux of the issue raised in the petition, where Lordship has got 14A, Malas, 14A third line. The crux of the issue raised by the petitioner remains that the direction to hold the trust vote was an illegal act because the governor did so by recognizing a faction of 34 legislators. The CM's participation or absence of participation would not dilute that fundamental illegality. If it's illegal, it's illegal. How does my non-participation validate the act of the governor? Is the core question. That's the correct legal answer. In law, since the illegality of 28 was already sub judice, so prior is important, and pending in a court, a participation or absence of participation of ex-CM could not possibly affect the prior illegality, which is already sub judice. Now, as an example, if one, this is very important, if one were to assume that I had subjected myself to the trust vote, the ex-CM had subjected himself on 30th and lost, and after losing challenged the trust vote, it would make no difference in law because the trust vote was merely the consequence of the illegal act of the governor. And the challenge would still relate to the governor's actions and not to the trust vote. D, it is therefore obvious in law, Malas, that the consequence of an illegal act, emphasis on consequence, cannot determine the legality of that act or validate it. Indeed, it could also be said that the petitioners, having challenged the core illegality at the base, namely the governor's actions, without any delay, did not even need to challenge the trust vote. I could have said it's nothing but a consequence. Similarly, if the individual illegal actions are broken up, and there are different petitions, it is clear that for the purpose of legal validity, either the first act of the governor in calling for a protest or the subsequent act of the governor inviting and administering oath, the participation or absence of the ex-CM has no relevance. Now let's just go back up. Let's kindly scroll up on this section. Come to para 3. No, I'm sorry. Para Malas.
So this is the second point, no, Dr.
This is the second point, but just one thing is left here, Malas. Para 9. Para 9. I'm not troubling with A3. My submissions A to N are giving the law EBUs, meaningful, status quo ante, scrambled egg, fait accompli. All that is given with law, Malas. In that, kindly, Malas, do me the favor of treating it as having stated here. Now, Malas, number 10. Indeed, in Bomai, paras, etc. given, the overwhelming majority of 9 judges made it clear that the proclamation under President's rule under 356, there were 2 states involved, Karnataka and Meghalaya, is very important, is liable to be struck down and the dismissed government is fully entitled to be restored to office. But the only reason we are not doing it because elections have happened in the intervening period. Now, just this is very important. This has not been shown to your Lordship. Just give me a minute. 398 and others, 5 judges out of 9 say this. 5. First is Justice Jeevan Reddy with Justice Agarwal. The proclamation must therefore be held to be not warranted by Article 356 outside its purview. Cannot be said that the President was satisfied that the government of the state cannot be carried on. The action was mala fide and unconstitutional. The proclamation is accordingly liable to be struck down. And we would have struck it down, but for the fact that elections have since been held and a new assembly has come in. That's the only exception. Today, the illegal government is running. There is no elections. Then, and the person who otherwise, suppose the Lordship holds the governor to be bad, then a person not entitled to be holding the post of Chief Minister. How can, of all courts, the Supreme Court accept such illegality? If your Lordship's powers are unique in this country, in that even your Lordship's can go beyond the law. Not contrary to law, beyond the law. Then, what's the point if the governor's actions are held to be illegal? Actually, your Lordship would be giving a Pyrrhic declaration and accepting that the illegality has borne the fruits of its illegality and people have enjoyed it. Now, let's just see next one. In state of Meghalaya, it's very interesting, for the other state in Bomai, para 12 of my note. Again, Justice Reddy said, but for the fact that since the proclamation, fresh elections have been held to the assembly. So suppose Meghalaya had not had elections and Karnataka had, they would have restored in Meghalaya. We would have certainly issued the writ and directed restoration. Justice Sawant for himself and Justice Kuldeep Singh, our conclusions may be summarized. However, in view of the fact that fresh elections have been taken place and new assemblies have been constituted and all, no relief is granted consequent upon the declaration. Therefore, this is the heart of this point. Now come to page 1 on 189. The third point is 189. All right. That is coming separately. That's coming separately.
What is the point, Dr. Singhvi?
Yes. Now, a very strange argument was raised, de facto doctrine. Regularization and validation by 189. Mr. Salve argued at length. Mr. Mehta also argued, I believe.
189, I'm sorry to interrupt. What is 189?
No, page 1.
Page 1 of my note. That is, the de facto doctrine that actions validated by the actual act, which is challenged, is illegal. I want to show how wrong this can be and how dangerous it is. Give me just 2 minutes. The case law makes it clear, but just come to the case law later. Just give me 2 minutes. The first important thing is to note that there are two kinds of challenges. One is a challenge to the very validity of the act. Come to para 8 of my note. So I challenge a validity of an act. Let us say the Governor's Act. Let me say competence of a legislation. Let me say fundamental rights. Versus the eligibility of certain people to act under the act, to sit there and act. Your Lordship under 189 protects the second, not the first. If the governor's action is bad, will 189 ever protect it, Mr. Learned friends, two of them argued at great length on 189. Did they answer the question? Ultimately, the core question, my lord, is just formulated either way, this way or that way. Is the governor valid or not valid? If your lordship holds him to be invalid, 189 comes only after your lordship holds something to be invalid. Otherwise, it doesn't come into play.
It is said in the context of the vote in the House.
So,
with respect to
exactly. So, therefore, no. 189, your lordships can and may, and in this case, perhaps should, in the intervening period of 7-8 months, the decisions taken by an otherwise illegally constituted government may be valid under 189. That's the real commonsensical way of implementing it, I am not suggesting that somebody's appointment is quashed, somebody's transfer is gone, somebody's policy decision.
So what
Maharashtra government has made a liquor policy, therefore that is gone.
What you're saying is that Article 189 recognizes a de facto doctrine.
De facto doctrine.
What the de facto doctrine does is to legitimize the acts of an authority whose original appointment is found to be invalid.
Subsequently found to be
invalid.
Correct.
But that does not validate the original appointment
that's
itself.
That's the one sentence pithy summary. Just give me a minute. Come to D, 8D. 8D. Or calling for that goes back to the same thing. First act was what? The governor being approached, governor calling. The two others are consequences. Voting is a consequence of the governor's illegal act. So is the oath taking. If the original act is bad and your lordships can't validate it, then this will not validate the vote. The consequence is bad. The consequence of an illegal origin cannot validate the illegal origin. And similarly, 189 cannot.
What you're saying is that if the calling of the voting in the House itself is subject to...
Just how my lords formulated was right or wrong. Governor's action, A, no basis, and B, if basis, it is wrongly applied, etc.
But that's the affirmation of the House, right? Then what? I mean, I still have it.
Affirmation is coming. That's this section. Bomai dealt with the affirmation.
All right.
Bomai said, we hold something to be illegal. Let's kindly give me a minute. This is very interesting. But thereafter, Parliament has approved it. Exactly the same thing. How can we quash it? Said, no, sorry, it will be quashed. Can you come to that now? So first, let's come to, yes, I'll just show 50. Just keep 356. Sima's query answered by Bomai. Para 4 of my note, this note. Much worse, fellas. Here there was nothing, in our case there's nothing. There was a presidential proclamation affirmed by Parliament in Bomai. Now come to para 4. It is respectfully submitted that the said contention is misconceived, liable to be rejected. In Bomai, does my lord have it? Para 4. Do my lords have it?
Yes.
Considered the effect of approval of a presidential proclamation by both houses on the legal validity of the proclamation when it is questioned before the Constitutional Court, held a clear majority, 5 judges, that if a proclamation on 350 is invalid, the same as liable to be set aside even if it has been subsequently approved by both houses. Your lordship is told 289, 189. This is express approval. This is express approval. Now read this para. Very interesting. 110, Justice Sawant for Justice Kuldeep Singh.
We'll check this up. We got the point. I mean, you're saying that the Bomai has a...
Now there is one interesting, very interesting, after 29 years and 2 days, this is happening in a lordship's court. This para 110, that bold face line by Justice Sawant says invalid. Lordship got the second line underlined.
Yes.
All the books, say it's valid. SCC. SCR correctly says it's invalid. SCC for 29 years and 2 days called it valid.
I hope you're citing our ESCR, Dr. Singhvi.
No. We've checked up. Then they issued a corrigendum. When my learned friend's colleague here, sitting here, pointed it out, then the SCC
Dr.
issued a
Singhvi,
corrigendum.
I must also publicly acknowledge there was a glitch in our ICT infrastructure overnight. My team was working till 5:30 in the morning. They began working yesterday.
Oh, I see.
They left for their homes at 5 o'clock in the morning, 5:30 in the morning, to ensure that we are all
It's very creditable.
we are ICT enabled.
It's very creditable.
And unlike the private sector, they wouldn't get even a rupee worth of bonus. It's just a love for the job that they do it.
The time, money.
Private sector is senior education.
Your Lordship is entitled to judicial right.
Batao. You are part of them.
Was.
No, this is just an aside. The word
saying private sector or senior councils, I said. Chief is saying.
some of your lordships, most of your lordships.
I told my learned brother, you are part of them too.
Complete estoppel.
Estoppel, that's why I didn't say.
And a very recent estoppel, relatively. Now, the word invalid here is by corrigendum the correct word. It is in the SCC valid. So it can't be valid. Just note that. What is the legal consequence of actions taken by the President if the proclamation is invalid, yet it is approved by both houses? Come to 111, Lordship. You see, I am racing only on the underlined portions. The proclamation will not make any difference to the legal status. Express approval. Forget 189. Parliament expressly approves. The action will undoubtedly be illegal. Then we'll skip 10 lines. There is no reason why the Council of Ministers and the Legislative Assembly should not stand restored as a consequence of the invalidation of the proclamation, the same being the normal legal effect of the invalid action. In the context of constitutional provision which we have discussed, and in view of the power of judicial review vested in the court, such a consequence is also a necessary constitutional fallout. Necessary constitutional fallout.
Get the point.
Unless such result is read, the power of judicial review is nugatory and meaningless.
There is a constitutional permissible, it's permissible to have a complete restitution, is what you're saying.
Otherwise, it's meaningless and nugatory. The 9 judges say that, and next sentence highlighted. Hence, the necessary consequence of the invalidation would be the restoration of the ministry as well as the Legislative Assembly. Then para 114, boldface. Secondly, the court may invalidate the proclamation whether it is approved by Parliament or not. The necessary consequence of the invalidation could be to restore the status quo ante. Therefore, to restore the Council of Ministers and the Legislative Assembly as they stood on the issuance of the proclamation. So, if your Lordship is otherwise convinced, your Lordship needs no support than more than a 9-judge bench, which is very clear. It may, however, to be made clear, next sentence is very important, next boldface. It is, however, to be made clear that the interlocutory relief that may be granted on such challenge to prevent frustration of the constitutional remedy. It is not to prevent the constitutional authority from exercising its powers and discharging its function. And then to conclude, the court in appropriate cases not will be justified in preventing holding of fresh elections, but will be duty bound to do so by granting suitable interim relief. Then, they summarize the conclusions, which I will not read to save time. Clearly, para after para is devoted by Justice Sawant and Justice Kuldeep Singh. And just see 7, another phrase, molding of relief, big Roman 7. Otherwise, what's the point your Lordship is exerting so much, if your Lordship comes to that conclusion with great respect? And that to a court with 141, 142 and special powers. I can understand the High Court possibly flinching. According to me, even the High Court has the power to do it under your Lordship's judgment. Now, Justice Jeevan Reddy said this, even in case the proclamation is approved, it would be open to the court to restore the state government to its power. If this were not conceded, look at these words, 9 judges, 29 years ago. If this were not the case, the very power of judicial review rendered nugatory, entire exercise meaningless. The court cannot grant the relief flowing from the invalidation. It may well decline to entertain. Well, they say if you can't grant the relief, why did you entertain? That's what this court is saying, 9 judges. And then Justice Pandyan, just 2 lines above 4A. I find myself in agreement with the opinion of Justice P.B. Sawant on conclusions 1, 2, 4 to 8. This includes my conclusions, which I have just read, 4 to 8. So this is, the 3 points are covered: prohibitory, affirmative, 189, and resignation. Now, the 4th point is this prospective and retrospective of the EC. They're all important queries which fell from my Lord. My Lord the Chief Justice asked this question more than once.
That is C.
That is, Balas, my C, my lord is right, pages 8 to 10.
Page 8.
Just, Balas, forget everything else. I'll take one point here is enough. Balas, whatever else your lordship holds, on the bare text, textually and facially, symbol order number 15, has to be prospective, Balas. Forget all the, we'll come to the interpretation. Just read the text facially. That's at para 15A of my note.
Yes.
Without anything more. We'll come to the consequences. Well, as drafted facially, without any interpretation, it has to be only prospective. Kindly read. Power of the commission in relation to splinter groups. Now, I've underlined some words. I've taken the liberty of underlining some words. When the commission is satisfied on information on its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party, the commission may, after taking into account all the available facts and circumstances, and hearing such reps of the sections or groups and other persons who desire to be heard, decide that one such rival section or group or none of such rival groups shall be binding. Well, this cannot but be futuro. Number 2, look at the consequences of holding otherwise. There will be very, very strange consequences. 2 things, fellows. If your lordship were to hold the 19th July, that's the date, order of the EC. 17th February 23. I'm sorry, 17th February. Petition is filed on 19th July. 17th February is the order. Now, fellows, the order to be retroactive, question number 1, retroactive from when? There are 3 possibility retrospectivities. Look at the consequence. Whether the lordship doesn't hold it to be without the consequence. 3. One is, it is retroactive from the date the Shiv Sena was recognized as a 29A political party. That was in 1990 or 92. I'm giving you 3 alternatives. I'm not... because today I am the election commission, I hold that this is the Shiv Sena. If it is retroactive, logically it should go to the date when 29A. But let's leave that. Second, it goes back to 21st June when this action started. And third, it goes to 19 July when the petition was filed. There are only 3 possibilities, Balas. In all of these, the consequences would be that, Balas, actually everything, I would be guilty, but I am actually, I mean people who have remained with Mr. Thackeray. I'm just using a phrase because there's no other phrase available. And people who have left. Now, the people who have followed the 10th schedule and remained with Mr. Thackeray would be actually liable for disqualification if your lordship relates back that. So your lordship would be giving a premium to those who follow the 10th schedule, and the people who have not followed the 10th schedule will protect their disqualification also and disqualify me also. Whereas your lordships will not avoid the inevitable consequence by Balas. Of course, your lordship's words can always Balas, but that's the logical consequence of retroactivity. They would make an arc of immunity for their own disqualification and actually be liable because the party from 19th July, any whip, any order, everything, I have violated because I'm not the party from 19th July. And therefore, Balas, I'm liable to something or from actually, logically speaking, from the origin. Therefore, Balas, this... And Balas, it would have the strange effect of an election of Mr. Uddhav Thackeray in 2018. Would also go without there being a fresh election unseating him. Everything will go, Balas. No adjudication. By the mere act of recognition relating back either to 1990s or to 19th of July or to 23, 21st of June, there would be chaos. The consequences are, and apart from the fact that this is clearly textually not intended by the symbols order. The fourth and the last, under this head, I'm not on the next one, under this head, it would also destroy, not collateral damage, major direct damage. It would destroy the relating back which is held by a lordship of Rajendra Rana. Now, note this, note this. Not a single judgment even of any high court, leave aside Supreme Court, says that the election commission will relate back. A constitution bench has held the field for very long, saying a disqualification 10th schedule order relates back. If your lordship were today to do this, your lordship would be giving primacy to an order under a symbols order, with any judicial precedent not saying so, versus a constitutional provision already held by a constitution bench to relate back. And your lordships cannot reconcile a relation back of disqualification with a relation back of the EC. It can't be reconciled. Today, Malas, suppose tomorrow the speaker disqualifies Mr. ABC. It is common ground by Rajendra Rana and many other cases. It relates back to Malas, June 22. But there cannot be disqualification because by then your lordship also would be applying a EC order retroactively. Therefore, Malas, your lordship already has jurisprudence and a precedent.
Prospective according to you. All right.
Then, Malas, the fifth aspect is this political party and legislative party.
Dr. Singhvi, now 5 minutes now.
Malas, we will finish before lordship's time. He will, within this time, we'll finish. We are conscious of that. Malas. 3:45 minutes, we'll finish within time. I'll give him 5 minutes also. He'll have 5 minutes. Now, Malas, F is a very important part. Actually, it goes to the root. This is the political party versus legislative party debate, but from an angle different than Mr. Sibbal's. This is very well different. Kindly, Malas, read this from a different perspective.
F, right?
Yes, F. Starting para 35, page 12. Well, as members of a legislature party do not have any right to act contrary to the directions of their political party. This is the heart of the political party, legislative party debate, with which Mr. Call also started today at 2 o'clock. As per 194(1), the freedom of speech is subject to the provisions. I pointed it out already. Under 170(1), the assembly of a state consists of members. The members are elected by direct election from territorial constituencies, and the nature of the election process is such that an elected member set up by a political party has no independent identity in the House except as a member of the political party. Well, actually, in practice, how we sit, where we sit, which rooms we are given, is all based on the collectivity of a party. Not an individual. Suppose a member is a leader of a party, he is very, very senior, but that party has only 3 seats. And another party with yesterday's first-time member, but the party is a large number. Seats are allocated, rows are allocated, rooms are allocated only on the basis of party. That's the way it has to be. Now, prior to introduction, this is very, very important. Just kindly see this. This evolution has been forgotten in this argument of political party and legislative party. Prior to the 10th schedule, prior to 85, the constitution did not mention political party anywhere. Although in parliamentary democracy, the heart, as your lordship has in the English books, is political party. Westminster model is political party. Even though political parties were always recognized to be an essential component of the Westminster form of parliamentary government, political party as a term was defined for the purpose of election law in para 2H of the symbols order. Thereafter, through amendments, the ROPA, the Representation of People's Act, was put political party. They are the 2 statutory levels. It came in Malas for the first time with the 10th schedule, which is a constitutional recognition of political parties. And today, a lordship is being asked to negate that recognition. Next para. On the other hand, the concept of a legislature party has no legal or statutory basis. A legislature party, by its very nature, is not a permanent association of persons. Its life is coterminous with the term of the House. The very coming into existence of a legislature party is dependent on a contingency, the success of more than one candidate belonging to a political party. The 10th schedule defines a legislature party in terms of a political party. That is conclusive, I say. According to me, I may be wrong. It's conclusive. Legislature party is defined in terms of the political party. I've quoted the definition. And Malas, your lordship is concerned with a whip. Whip is peculiarly a political party activity. I'm 41. The purpose of defining the group of members of the House belonging to one political party as a legislature party can be gathered from the number of times when legislative party is used. First, in 2.1, it says a member of a House belonging to any political party. What does it mean? Do you have an existence or identity other than the political party? After constitutional amendment and definition? Then, Malas, There is no mention of legislature party in para 2. None. In para 2, political party is mentioned. Thus, while referring to individual members, the 10th schedule refers to them as political party to which they belong and not relation to legislative party. The only place in the 10th schedule where the term legislature party is used was either para 3, now gone, or para 4. In para 3, the term legislature party was used when the fraction of 1/3 goes below. In para 4 too, it is for merger. Doesn't arise in this case. Doesn't arise in this case. Thus, wherever the 10th schedule provides protection to a group of legislators when acting as a group, it uses the term legislature party. Otherwise, it is described with reference to political party. Now, what is the consequence? This is a little important. The constitutional sequitur of this discussion is that a majority faction legislative party has no constitutional identity except for the purpose of setting up a defense under 4. This is important. Today, there is no status identity of a legislature party except for the defense of merger. That's all. And admittedly, that's not your case. If no defense is claimed, the legislature party has no constitutional or legal relevance as para 43. Therefore, the group of legislators belonging to a political party can have no right of dissent or conscience. This dissent argument. Dissent has to be within the parameters of what 10th schedule allows you. Dissent cannot say and that's too broad a basis for your lordships to act or give any judgment on ones. Dissent. I just say I'm dissenting and I leave the 10th schedule. Reliance is placed on the law of speaker, where deho the legislative assembly, disqualification rule, the president of the political party who was not a member was given the right to maintain disqualification. Well, this dissent point which your lordship put to me just now also, let me end on that. Just see Justice Venkat in Kyoto. That para has been read one sentence, but read the whole of it. This is directly the point raised in Kyoto. Your lordship should not be referring to Nabam Rebia, lordship should be reconsidering Kyoto also on this basis. Now kindly see. This is a very important para. Para 49 at PDF page 109. 109. Very telling para, directly the same sentiment. How do you harmonize the two? And you cannot allow one to be reduced to vanishing point. Kindly see this. And I'll end in about a minute or 2 minutes. Indeed, in a sense, may I read this, fellows? 109. This is very, very important. It's a covered field. Your lordship need not be agonized about it, as my learned friend would like your lordships to raise a new issue before. It's a covered point.
109.
109 PDF, CJ2?
CJ1.
CJ1. Inappropriate acronym, Malas. We used to call it CL1, Malas. Case law 1. I don't know where this time. First time I found CJ1, Malas. Indeed, in a sense, an anti-defection law is a statutory variant of its moral principle and justification underlying the power of recall. What might justify a provision for recall would justify a provision for disqualification for defection. Now, kindly see the exact sentiment which my lords expressed to me. Unprincipled defection is a political and social evil. It is perceived as such by the legislature. People apparently have grown distrustful by the emotive political exaltations that such floor crossings belong to the sacred area of freedom of conscience or of the right to dissent or of intellectual freedom. Can't be put better, Malas. The anti-defection law seeks to recognize the practical need to place the proprieties of political and personal conduct, whose awkward erosion and grotesque manifestation, it's grotesque in 92, I don't know how much more grotesque it is now today, especially with the 4-step procedure here, whose awkward erosion and grotesque manifestations have been the bane of the times, above certain theoretical assumptions. Theoretical assumption. My learned friends have raised a theoretical argument, which in reality have fallen into a morass of personal and political degradation. We should, we think, defer to this legislative wisdom and perception. The choices in constitutional adjudications quite clearly indicate the need for such deference. Let the end be legitimate. Let it be within the scope of the Constitution, and by all means which are appropriate, which are adopted to that end. And here we have added, I have added 4 clear escape routes or mitigating circumstances. You don't follow them, but you follow this. This is extremely unfair. This is again like that technique of giving a notice to the speaker. It is trying to decimate the entire 10th schedule by saying dissent. Dissent has to be within the boundaries. But I'm extremely grateful and
Thank you, Doctor.
very deeply obliged.
Thank you, Doctor.